Disney has filed suit against Ron DeSantis and the entire board of the Central Florida Tourism Oversight Board, the CFTOB, as well as the administrator of the CFTOB, formerly Reedy Creek. And today we're going to talk about this Disney versus DeSantis lawsuit, give you the main points, the points you can share with everybody on this for exactly why Disney will lose. I guarantee you this, they will lose on this case. I am Andrew Esquire. I am an American attorney, specifically a Florida attorney, the most experienced attorney that I know in the realm of real property and special district law. This is what I did for almost a decade, and I can tell you with absolute authority on this issue that Disney will lose. They do have this completely wrong, and I'm going to tell you why today. First off, this is the case that was filed in the Northern District of Florida. Now, this is a federal case. Disney intentionally chose to file a federal case, and we're going to talk about 3 points on why they're going to lose, but number one has to do with that. And first of all, we're talking about property law, not contract law. And that's one of the biggest things to start out with here when we talk about the reasons why they are going to lose. So when we talk about state versus federal, what you have to understand is in the law, there are certain issues that are federal questions and certain issues that are state questions. Now, if there's an issue of a civil rights violation, right, that's something that typically is looked at the federal level, although many states have laws against that as well. But something like property law is quintessentially state law. It looks at the laws of that state because property law varies wildly state to state. You cannot take property law from Florida and apply it in California. It just does not work. And this is where the Mouse and the Mouse's legal team is wildly off the mark. None of them understand property. Certainly none of them understand special districts. And they have absolutely no idea that this is not some sort of contractual issue. This is deeply rooted in real property issues. So that's something that is a state issue, not a federal issue. So just off rip, when you look at the top of this and where it was filed, just from the jump, that is a big fundamental flaw of this case. And property law is much different than contracts. Throughout this entire complaint, Disney tries to compare these restrictive covenants and things to contracts. And while there are certain elements of real covenants that function similar to contracts, they're not exactly the same. There's some things that you can contract for that we've said, hey, we don't allow that in real covenants. For example, you have to touch and concern the land, right? There have to be provisions in those real covenants that relate to the land. There's many ways to terminate real covenants. And there's certain things, for example, real covenants do not apply against governments. That's been a long-standing principle under Florida property law, which, hey, under contractual law, yeah, you might be able to make that fly in California, but it does not fly under Florida property law, and it would not fly in a Florida state court, which is exactly why they bumped this up to federal. And let's move us over to point number 2, which is the precedential effect. When lawyers talk about precedential effect, we talk about what is this going to do for the future? What is this going to do all across America? Remember, this is a federal case, so it has potential ramifications, potential consequences all across the United States. So if they ruled in Disney's favor, what would this be doing? So I'm giving you like the outcome if they ruled for Disney. Let me just explain that to you real quick. In this lawsuit, what they're asking here and what they're essentially asking is for all HOA covenants, right, restrictive covenants, if they were all viewed like contracts, if they were all viewed as federal issues, then every single HOA across the entire United States, whenever there's an issue with their restrictive covenants, they would be able to bring a federal claim. That would result in what we call a flood of litigation, right? So people would be flooding into federal court to litigate their HOA restrictive covenants. That's ridiculous. That's preposterous. They will never allow that. If only for that. If only because courts do not want to deal with that. This is something that ultimately will be blown out, even just for that point alone. But we don't stop there. Also, remember how I said a restrictive covenants can't control governments? That's a long-standing principle. Look, flip this on its head, give it another whole picture. In fact, let's invert it. Let's say that Elon Musk in Austin, Texas, a liberal city, he forms an HOA. And that HOA says every single Austin city building, every bus, everything within the limits of this Twitter HOA, it's got to have the Twitter tramp stamp on it. It's got to have that bird, right? Maybe it also has a Dogecoin right next to it. Would that be something that the government should be enforcing? No, the government has no business enforcing that. That is a private thing. It is non-binding upon the government, right? They can do whatever they want on their property, on private property they control, but governments are not bound by restrictive covenants. That's very clear, especially under Florida property law, and that's something they try to bury here. But the precedent would mean that HOAs all across America could control governments. That's not happening. Private communities controlling these governments, no way, not happening. And the other thing about precedent is a lot of this, and this gets towards the third point, but a lot of this has to do with what Ron DeSantis has or has not said. And if we start the precedent of bringing a federal case every time a politician says something mean or that you don't like or that hurts your feelings and that you perceive to have had a bad effect on your company, we would have a flood of litigation, an absolute windstorm of litigation, which brings me to that third point. Hurt feelings are not actionable. Just because Disney cannot push its woke agenda and just because they can't frame this argument the way they want to frame it, and they're mad that they lost essentially something that was given to them in the past at a time of really high corruption, that is the Reedy Creek board, just because they're mad about that and mad about what Ron DeSantis said, that doesn't make any of the actions invalid. In fact, Disney does not contest anywhere in this complaint the dissolution of RCID, of the Reedy Creek board. It, in fact, does not say at all that the Central Florida Tourism Oversight Board was set up or established illegitimately. Not at all. So it acknowledges the power of the CFTOB and that Reedy Creek is gone and dead. These are facts. These are things that are not alleged at all in this complaint. And because of that fact that that's not in there, it's not challenged. And really, if you look at their causes of action, they've got 4. 2 of them, the First Amendment claims, are specifically really against what Ron DeSantis has said, his personal views, and by implication, applying those to the board members as well. That's not something that's actionable. That's not something in this country that we find actionable. And for these reasons, Disney is absolutely going to get blown out. If you want a more in-depth coverage of this, check out my live stream from Thursday, April 27th in the 7 p.m. Check out that live stream. It's going to have a longer version of that. Make sure you like, comment, and subscribe.